If you're the executor or personal representative of someone's estate in a probate and you have real estate to be sold, maybe it was the decedent's home or a second property, you need to know what a personal representative's deed is. I'm going to call it a PR deed for ease today. But you need to know what that is because that's what you should be using in the sale of that property in the probate. This is specific to Washington State. So if you have a probate that is outside Washington State, it can be called something different. It may be called a bargain and sale deed or some other type of limited deed. So this is not going to apply if you're not in Washington State. But if the decedent and the probate is in Washington State and there's real estate to be sold, this video is for you. So let's start with the probate process and what the executor or personal representative is, because sometimes I have questions as to even what that is and what that means. So that's someone who's, if there's a will, they were named in the will, and I'm going to call a personal representative a PR because it's just easier. So when I'm talking in the video, so someone's going to be named in the will either as an executor or as the PR, personal representative, in that person's will. So the court has appointed that person to act as the PR of the estate of the decedent. And one of your jobs as the PR is to liquidate the decedent's assets. What does that mean, to liquidate the decedent's assets? That really just means get everything sold or transferred to whoever it's going to go to pursuant to the will. So a lot of times you are selling real estate, you might be selling vehicles or other personal property items, you might be closing out bank accounts, investment accounts, things like that. So part of that process, if you have a home in the decedent's estate, is that you need to get that home sold. And so usually if you're not the one buying the home out, or someone else, one of the heirs aren't buying the home out from the estate, and we can go into detail on that in a different video, but if you're selling it on the general market, right, you're usually going to be listing it with a real estate agent. And so you're going to find your real estate agent. If you need referrals, you're going to be asking me or your attorney for referrals for a real estate agent, and getting the property valued, getting it ready to be listed, and getting it on the market. As part of that process, when the home is being listed, there are some additions that or instructions that I give the real estate agent or real estate broker as far as that listing agreement. And there's a couple of notable things. One of them is that a probate estate is exempt from Form 17, the seller disclosure form, so I have them add that. We make sure the seller is named correctly on all the listing documents and the contract itself as the estate, and the executor being named as the executor or PR and not in their personal capacity. But we have a whole addendum that we provide to the listing agent as far as kind of outlining those details. And one of them is that the transfer of the property is not going to be as a statutory warranty deed, which is usually used in most sales. Instead, it's going to be a PR deed. And so that limits the liability of the probate estate and of that PR as far as the warranties that they're giving with that property, because the estate or the PR, you don't know anything about the property, you don't know anything about the boundary lines or anything else that an actual owner may know. So you don't have to give those warranties or guarantees that a traditional seller would be giving. And so that's why we have the PR deed used to transfer title to that new buyer. Now, you're still going to have a title company involved, right? There's still going to be a title report and title insurance and making sure there's no liens on the property, or if they are, they get paid at closing, all the taxes get paid, the utilities get paid, things like that. But we want to make sure that we are limiting the liability of the probate estate. And one way we do that when selling real estate is with the PR deed. Now, sometimes in probate, depending on what escrow company you're using, sometimes the escrow company is able and willing to prepare that PR deed. And if they're not, that's fine. Our office will do so, or whoever your probate attorney is should be able to prepare that deed for the transfer of that home to a buyer. So again, if you are the executor or PR of a probate estate, whether that probate is open now or going to be open in the future and there is real estate to be sold, make sure you're asking your probate attorney about the PR deed and that is what's being used to transfer title to that new buyer. If you need help with a probate or even with your own estate planning, give our office a call or visit us online. I'll have all of our contact information below. Thanks.